The SEC may decide to reclassify XRP as a commodity, which would have a significant impact on its legal status. Ripple may be subject to a lower fine, which would change the outcome of the action brought by the SEC. According to the opinions of legal experts, the current injunction is a significant barrier to the expansion of Ripple. It is possible that the lengthy legal struggle that has been going on between Ripple Labs and the United States Securities and Exchange Commission, SEC, could soon come to an end, as stated by Andrew Parrish, who is associated with Arch Public. On the 17th of March, 2025, Parrish disclosed on X that two sources from the SEC indicate that the case is getting closer to its conclusion. The action, which was initiated in December 2020, is centered on the SEC's accusation that Ripple raised more than $1.3 billion through the sale of unregistered virtual currency, XRP. Reactions from legal professionals and members of the cryptocurrency community have been prompted by recent events that indicate a change in the trajectory of the case. In August of 2024, Judge Annalisa Torres concluded that Ripple's institutional XRP transactions violated securities regulations. As a consequence, the company was ordered to pay a fine of $125 million and to refrain from engaging in such transactions. The court ruled that programmatic sales made to retail investors were not prohibited under present restrictions. The news from Parrish meets emerging forecasts regarding a future regulatory solution which should clarify both XRP's standing with regulators and Ripple's operating capacities. The future of XRP is determined by possible outcomes. Parrish provided an overview of the most important outcomes that could occur in the lawsuit. According to his point of view, the SEC might grant XRP commodity status, which would result in a paradigm shift in the market laws that are associated with it. The Securities and Exchange Commission, SEC, has recommended a change in market classification that would be the opposite of its previous attitude, while also mirroring the ruling that the court made regarding the treatment of retail sales. Moreover, Parrish made a veiled reference to a decreased fine, which would alleviate the financial load that Ripple is now under in comparison to the existing penalty of $125 million. According to Parrish, the new leadership of the Securities and Exchange Commission appears to be aware of the case's wider significance. A ruling made here could establish a precedent for the regulation of cryptocurrencies in the United States, which would have an impact on the way digital assets are managed in the future. Eleanor Terrett, a writer for Fox Business, reported last week that Ripple is purportedly discussing the removal of the injunction that restricts institutional sales. In the meanwhile, the injunction continues to be a barrier. Experts in the law comment on recent developments in the Ripple case. Several prominent attorneys have responded to Parrish's allegations with a mixture of cautious optimism and skepticism. An attorney who supports XRP named John Deaton tweeted an eyes emoji on X, which indicated that he was surprised or uncertain about the projections. Another supporter of XRP, Bill Morgan, praised the beneficial qualities of the cryptocurrency, such as the commodity classification, but expressed concern regarding the injunction that has not been settled. The fact that this restriction continues to hinder Ripple's entrance to the institutional market was stressed for him. There is new speculation regarding the withdrawal of an appeal and a settlement in the SEC vs. Ripple case. On Monday, March 17th, speculation regarding a possible withdrawal by the SEC in the Ripple case escalated. This comes as Ripple's appeal-related reply brief filing deadline is drawing closer. Update: two sources within the SEC feel that the Ripple case is extremely close to being resolved. The following are some anticipated results. Anticipate that XRP will receive substantial consideration as a commodity. The fine has been much decreased. It has been greatly lowered. The newly appointed leadership is aware of this matter, and how they treat it will set a precedent. As a result of the fact that amicus curiae attorney Johnny Deaton reposted Parrish's tweet, the claim gained more credibility within the cryptocurrency world. Eleanor Terrett, a former journalist for Fox Business, has previously identified two sources from the Securities and Exchange Commission on March 12th, stating, "My understanding is that the delay in reaching an agreement is due to Ripple's legal team negotiating more favorable terms regarding the August District Court ruling, which included a permanent injunction that prevents the company from selling XRP to institutional investors. The ruling assessed a fine of $125 million against the company and included a permanent injunction. Speculation of the SEC withdrawing its appeal may become more prevalent in the upcoming sessions. The case may undergo a substantial transformation if the Securities and Exchange Commission, SEC, decides to withdraw before the appeal-related reply brief filing deadline of April 16th. Investor reaction was modest as they waited for official confirmation of the likely withdrawal of XRP from the SEC, which continues to be one of the most critical catalysts for the cryptocurrency. While this is going on, reducing the penalties to $125 million and removing the order that Judge Torres issued, which required Ripple to comply with Section 5 of the United States Securities Act, would be an additional boost. The SEC versus Ripple lawsuit reaches a crucial phase on Monday, March 17th, when the countdown to 1 month for Ripple to file its appeal-related reply brief begins. This occurrence marks the beginning of the countdown. To respond to the SEC's arguments for an appeal, Ripple is required to submit its reply brief by the 16th of April. On January 15th, the Securities and Exchange Commission, SEC, submitted its opening brief appealing the decision of Judge Torres on the programmatic sales of XRP. Changes at the SEC create uncertainty regarding the appeal. Following the filing of the opening brief by the Securities and Exchange Commission, substantial leadership changes have reconfigured the regulatory landscape. SEC Chair Gary Gensler has resigned from his position. A crypto-friendly former SEC commissioner named Paul Atkins was put forward for the position of chair by President Trump. To serve as acting SEC chair, Trump selected Commissioner Mark Uyeda, who is a proponent of cryptocurrency. Acting Chair Uyeda was the one who initiated the Crypto Task Force, which Commissioner Hester Pierce was in charge of leading. Because Jorge Tenreiro, the SEC's primary crypto litigator in the Ripple and Coinbase lawsuits, was transferred to the IT department, questions have been raised over the agency's attitude to the enforcement of cryptocurrency regulations. The Securities and Exchange Commission formed the Cyber and Emerging Technologies Unit after disbanding its crypto assets and cyber unit. The CTU is constituted of 30 fraud specialists and attorneys. The confirmation of Paul Atkins would be the final stage in the reorganization of the SEC, which may potentially reinforce the agency's turn away from transactions involving cryptocurrency that do not include fraud. As a result of the reorganization and the anticipated shift away from cases that are not related to fraud, speculation has been stoked over the possibility that the SEC will withdraw its appeal in the Ripple case. A withdrawal of the SEC's appeal is possible. An appeal strategy for the Securities and Exchange Commission, SEC, may need to be finalized by Acting Chair Uyeda and Crypto Task Force Head Pierce, because there is no confirmation hearing date scheduled for Atkins,